Am I demoting him or increasing his status? Judge John Arnold failed even to schedule hearings on motions to vacate this unlawful order terminating child's contact with her father for over 2.5 years. I'm not sure if that's awkwardly, too awkwardly phrased, but an order came about that terminated the child's contact with the father. The order lasted for 2.5 years by chance, or was there an order that was sort of a standing order that you can't have contact? Well, anyways, that I was thinking as a little clarification, because I don't think that line is a very good one. And then, but so you have a difficulty again, and I wonder how you handle that for us. That the absence of documents. You know, if we fail to give an order, obviously the absence of documents. What would be looking at?
I have the documents I filed asking for this motion to be vacated, so I have a copy of those.
Right, and the difficulty is in historically or in your activities with regard to the courts is that normally that a motion would be made and a docket time would be sent. I mean, a time would be sent for you on the docket where a hearing could be.
No, how you file something and then you hear back sometime later if you get a notice at some point about when the hearing will occur.
But the judge will otherwise say denied a hearing, but he'll also respond to it that way.
Well, they can respond saying it's denied, dismissed, granted.
Right.
They don't have to have a hearing.
So you're saying what happened over 2.5 years was not that there was no responses?
There was no response.
Right.
Yeah, we wanted an order. So the thing is, we don't have an order. I can't appeal it. Can't do anything. You're just stuck.
Where would we see a list of responses? Is there other responses that we would be, for example, you made it, put it in a motion or something other, and you got a response back? I'm just trying to see if there's any way this committee could verify.
In the case file of every case in the court, there is there's the docket listing, everything that's in the case file and when it was put in there. Okay. And that's the master copy there.
Right. That would be it. Now, would we have that?
I don't have a copy. They'll have it. I have pages from different times, but there's over 300 and something pleadings, entries in that.
Yeah.
So it's lengthy. One of the difficulties with Cheshire Superior Court, this came out last summer, is because of the problems with the prohibition on cameras in Cheshire Superior Court. We weren't able to record anything in the court office. You could only get, we wanted to take cameras and take copies of the case file and the docket page. They wouldn't allow us to do that. I was there with some other people. So at the July 27th, 2011 hearing, that was the first thing that came up. So I said, why is it that we can't review the docket entries? And there was some question because they had been changed. Like something had been submitted, but the date had been whited out and changed, which you're not supposed to do on those things. I asked Judge Arnold about that. The very first thing, he said, we do that all the time. We change the dates on the case files and the dockets. We do that on your case, we do it on every case here. So you don't have a true record of when things are submitted.
Thank you. I'm confused by this paper right here that has GALK on it. Your case, according to this docket, started in 2005.
Correct.
This only has stats in April of 09. Is there some reason you don't have the original?
Well, I just wanted to show that I had paid on 3688 on 515 and the 4236 on 727. Those were the amounts that I was required to pay or risk incarceration.
Well, this is a half a story. In all due respect to you, this is a half a story.
It is half a story. The rest is in the other documents.
What other
Well, wait a minute.
documents?
Do we have the other?
Well,
You're saying?
of the billing, you mean?
Yeah. Well, the point is, you're making a single point that you gave us that for in here. That was under item. Well, it was under 6, right? Was that where your point was that you're short retroactive fees?
Yes.
And so that's what you're trying to support, and that's what that document does. I
Right.
think you're not looking for any more information, if that's what you're trying to support. You may be looking for more information. for other purposes, to support other things, but that's what he's setting that to for.
Well, I don't know that that's the whole story though, when I see it, when 4 years of the case has gone on before we even get to that point. I don't know if I'm seeing the whole story on that piece of paper.
You're not, I'm sure you're not saying the whole story. Representative,
Mr. Chairman, I'm told that in RSAs, the word shall is absolute, and I also hear that, may leaves discretion. In orders by Edwin Kelly, I'm not sure what the context of only means, but it said, a party desiring that a guardian ad litem resume, that's a real word, work on a case shall immediately file an appropriate motion and shall send a copy of the motion to the guardian ad litem who shall resume work in that case. Here's the magic word, only, note that, on receipt, I don't know what that word means either, I don't know if that's an invoice or something, but only on receipt of the court's notice that the motion has been granted. Now, I don't know what granted means there and the whole retroactive thing, but a half a story, we have a half a story. The half from the court says that they didn't follow the damn rule, and this, someone saying that we have the risk of someone being put in jail because the court didn't follow a procedure and says you didn't pay a bill, is a half a story. If the court wants to show up and explain it, that's fine, but we need to hold them accountable because I represent the people, and the people ought to be offended.
Thank you.
further questions on point 7? All right, we'll go down to, I'm sorry, so then the additional. It says additionally, the committee finds that Ms. Hamilton, this is the list of grievances related to Ms. Hamilton, failed, sheet number A was failed to produce the mandatory report. The demanded is a little excessive. The mandatory report by Family Division Administration Order, such and such, and the mandatory stipulation for fees and services. Now again, the difficulty is the failure to produce the order. Help us again with that, and how do we ascertain for our own purposes? Was that agreed to by the Cheshire reading of this, or was there, what's this, how do we get to, not by no means do we disbelieve your statement, but how do I get to the evidence? What is the evidence?
So the evidence for?
That she failed to produce the mandatory report.
We don't have any evidence that she didn't produce the report because it doesn't exist. The evidence we have to show that she did not produce stipulations is in that court order that first document I sent.
Yes.
And then in there it says the guardian ad litem did not produce stipulations.
So the stipulations is the second part of that. The mandatory report is just, it's just in the absence of.
Correct. It's in the absence of.
Okay. So we have to determine among ourselves in this committee whether we accept that on word, or, the word of the witness, or how do we deal with that? Representative Morgan.
She's still working on the case, and has there been any allegation from her side that she hasn't been paid enough to continue working on the case or anything of that nature?
She's been discharged from the case. She would also automatically be discharged because it was the end of the action. And your second question was, has she been discharged?
Well, was there any allegations that since the guardian ad litem is not just bound by the contract, so he or she is protected by the contract, so she's professional being paid.
Right.
So for whatever reason the payment stops coming, they're not necessarily obligated to keep working. So is there any problems?
She says that I owe her about $17,000. I say we don't have a contract, which is her stipulations, which I asked for in 2008.
So she billed you for $17,000 worth of work, which you probably, in your view, for good reasons, didn't pay for.
That's correct.
Yeah.
Mr. Chairman?
Representative.
Thank you. I'd like to make a motion that we strike the entire section C because Ms. Hamilton's actions were not properly authorized, and the committee finds that they were those of a private citizen, not an appointed guardian ad litem, making them liable under the law for attempted false imprisonment, RSA 629.1, 633.3, and interference with custody 633.4.
You can hold that off for a just a second, the B, we haven't gotten to it, where did B? We just-
Oh, I'm sorry, I thought we were done with B.
No, no. Well, maybe you were done, I did efficiently manage it in your own mind, but I had a public, I'm here, so. B is without proper stipulation, appointment, and without proper court authorization, but we've already have the document to show that that's the case, so we don't have further proof. I just wanted to make sure that when I read it, that point B was one of the points in regard to the GAL. Were there further questions on that point without proper appointment, without proper court authorization? All right, and then move to terminate contact between the bishop and the daughter. So that point is what leads to point C. She makes a motion in point C she's making. So what is would you like to bring it back to us again? I apologize.
I would like you to delete all of point C, the whole thing. As soon as the judge retroactively appointed someone as a guardian ad litem, the Supreme Court decision of April made that person immune under quasi-judicial immunity, and under a scholarly work called A Black Robe is Not a Large Tent, 56 pages. You'll find it interesting. It suggests that all of the courts, including a whole bunch of people in quasi-judicial immunity, is a problem of courts across the country and shouldn't be done. But since they've done it, as soon as they give that immunity, it doesn't matter what we claim. So even if we were to have that finding, it has no teeth, it doesn't matter. So I think we get rid of it and focus on the real issue at hand. Sorry.
For a point.
Thank you, Mr. Chairman. Just a little tongue-in-cheek, but just in the spirit of being retroactive, this took prior to that case, did it not?
Doesn't matter. I'm sorry, if I may. It doesn't matter. As soon as the judge says, I've done an enormous amount of reading on this because it annoys me so much. I went and tried to understand what happens. And, I'm a Star Trek guy, I'm a high-tech guy, and I sort of think of quasi-judicial immunity like the Borg. You never want to get touched, because once you do, it takes over. They give somebody quasi-judicial immunity, they can shoot you. It's bad. Yes, they can. Actually, the Supreme Court order says if they are given this, they have absolute quasi-judicial immunity, and that it covers everything, even their malintent, malice, and bad acts.
But non-criminal activities.
Yes.
I'd have to read further. I've never read that, but I'm not here to dispute. Representative, I would appreciate a comment on the last point, not on necessarily Mr. Lambert's point, but on the last point in here, number C.
From me?
And then, you, and just in that, by way of talking about the relative, the express sort of uselessness of this exercise in that point, do you have a sense of what would you find telling us what you?
Well, I know that she'd be liable under federal statute. So let's say she gets
Could
shooting
come
or
under
something.
recommendations then, instead of just being here involved at this point, is a complaint against her that?
Well, state judges are not immune under federal law. That's, for instance, why RICO statute violations, you can prosecute judges under federal law with that for racketeering and other things. A recent case in Pennsylvania, 2 family court judges were, not going to the whole thing, they were found to be corrupt, taking kickbacks, so on and so forth. So they were prosecuted and jailed. They had to pay back millions of dollars in ill-gained finances from that. So,
Would you agree that this is an incorrect statement, that they would actually be liable under law for attempted false imprisonment and interference with custody?
I think that Representative Lambert is correct, given state law and that grant of quasi-judicial immunity. I'm not positive. It's something that has to be looked at, I'm sure. But I think it covers them for stuff like this. She can take your child, she can try and throw you in jail, doesn't matter. She is given a cover of quasi-absolute judicial immunity.
Okay, so I take it that is without discussion.
Yes, I'm reading these papers you just passed out this morning here, and it says the court suspended your contact in June of 2009.
Yes.
It also says that you didn't appeal that motion until April of 2011.
until April of 2011. I didn't file a motion to vacate. Yeah,
Right.
that's a, yes, it says appeal.
Does that seem like a long time for somebody that wanted to see their daughter so desperately?
We were doing a custody evaluation, which was transpiring over that
10
time.
months?
My ex-wife would not comply with meeting with him. It just dragged on and on and on.
In all due respect, you didn't even file paperwork for 10 months for a child you wanted to see so desperately.
I filed.
What's going on?
I filed a motion immediately after that, after the June and July orders. I filed motions immediately after that.
So these court papers are wrong?
He said after what, he said after the 20.
Yeah, immediately after that, I filed some motions about that.
Was there a reason why you didn't file it before?
Pardon me?
Was there any reason why you didn't file it before? Was there?
We had a process that was set, which was a custody evaluation. So we wanted to get the custody evaluation its chance.
Which might have changed that. Which might have affected that.
Might have, yes.
That was the reason for waiting for it. I'm not trying to put it.
Mm-hmm.
Representative Horgan.
Well.
Apologize, I
Well-
was room for a couple of minutes, I may have missed something, but my understanding